Bonne conférence à vous.
Merci. Et cela marche ou je peux
Cela marche. Après, si ça ne dérange pas le micro, c'est mieux. Ça te va. Si tu restes là tout le temps, tu peux utiliser ça. C'est bon, le live est
bon? Hello everyone. Hey. Hi, thanks for being here. I'm gonna speak to you about DAOs and state legal systems. So, compulsory disclaimer, this is not legal advice. So I'm a lawyer qualified in Switzerland and usually do give more of legal talks. This is more of a law and philosophy talk. So please do not rely on what I'm saying in order to design your projects. Get your own lawyers, get your own legal advice. But nonetheless, I hope that this talk will be useful for you to give you another perspective on DAOs and state legal risk mitigation. What are DAOs? So I'm going to talk about DAOs without defining them, and a lot of people have tried to define what DAOs are. There is no one single definition. Every definition focuses on one feature or one aspect of DAOs, and I don't think that it is even possible to define it in a comprehensive and exhaustive way. What I'm going to do nonetheless is I'm going to focus on DAOs as a tool for civilization. So I strongly believe that DAOs can positively disrupt, if they are used as such, worldwide coordination of people, their access to resources, and the global distribution of wealth. And we have already seen this happening with the whole DeFi space. DAOs can also influence politics, culture, and moral norms. And two examples come in mind for this would be the Free Ross DAO or the Assange DAO. So DAOs can have a great impact for humanity or society if used as such. And this definition that I put on the slide does also reiterate what I just said, and this comes from the LexNode Substack, where they say that DAO is an inherently anarchist concept. So the autonomous in the term DAO is not meant to be automated, what many people may think, and which is not also excluding automation, but it is clearly and truly autonomous. True DAOs are not meant to be existentially dependent on a state charter or limited to compliance with a particular set of laws. So DAOs are this space outside of state laws, and nonetheless though, people feel constrained when they have a DAO project by what I call in this slide legal risk FOD. So people come to me, projects come to me often, they have a DAO project, they loosely call many things DAO, but this is another question. And they want to have some form of legal risk mitigations. They are afraid of some form of liability, of some form of consequences because of the way that they designed or they hope to design their project. And in order to deal with legal risk mitigation broadly, there are many strategies that one can adopt, and it depends a lot on one's posture, for instance, with regards to our own legal risk profile, the actual risks that they are exposed to, where they live, and so on. But in order to clarify what is even this risk we're talking about, I think we must absolutely answer the question of what is law even. And I Googled the definition of law, and the dictionary definitions usually say that law are rules created by a nation state and enforced by a government upon its constituent. So usually law is understood, and I think the way we use law in language has also the same meaning as what I call state law. So law is understood as emanating from a state and being enforced from said state. However, I think that we can also look at law as a way broader concept than only state law. And this is an excerpt from the Wikipedia article on law that says that law is a set of rules that are created and are enforceable by social, or governmental institutions to regulate behavior, with its precise definition a matter of long-standing debate. So law is greater than state law. It does encompass, obviously, state law and its bureaucratic system that helps enacting those rules and enforcing them, but it also encompasses all other moral and normative systems impacting our lives. And examples of such systems could be cultural laws or norms, religious norms, communities, even our own self-moral norms that we impose on ourselves and our behavior. So law is way greater than only state law. However, there's this law equals state law meme that has some purpose and consequences that should be at least acknowledged. By thinking that law equals state law, what we're actually doing is that we believe that state law is this all-encompassing thing that would govern on every single action or thought of all of us. However, this is not exactly true, and by having this in mind every time we talk about law, or if you want to be more precise about state law, we will remove this blind spot of thinking that there is this one system to which we are all subject. And DAOs here provide a form of negative space, which is not prone to interference by said state law. DAOs are not comprehensible by state law. They are not, state law cannot communicate with it. And this has been seen in many different ways throughout the life of crypto so far. And one of examples of this would be, for instance, tokens and how they are qualified or understood by state law. And there are always ongoing debates. States try to fit tokens in one of the boxes that they do understand in order to regulate it, but this does not exactly fit. Like, is token money? Is crypto a security? Is it a goods or a service? Is it a mix of those? It's oftentimes, other than some few exceptions, not a clear answer. So state law has a very difficult time to communicate with DAO technology and everything that comes with it. So DAOs could be understood as this negative space or this autonomous zone or even parallel society for those who are who know about this notion. So if we understand DAOs as this negative space, then we can ask ourselves the question of how does DAO posture vis-a-vis state laws. And here I broke it down into three different ways of posturing. And the first one would be just to remain outside of state law altogether. So to remove all form of communication between state law and the DAO. And this could be done in many ways, and here are some examples. One of those would be to just remain fully unincorporated, not belonging to any form of understood form of organization by state laws. It could be another way of doing this could be using code is law or governance minimization, for which I'm not necessarily an advocate, but it does serve this purpose of making the technology non-capturable. Using counter-economics could be another ideological, perhaps, way to remain outside of state law. And I added this last example of just having an anonymous team, making it extremely difficult for state law to capture the space of the DAO. This we've seen already happening in the space. I think we're going to see way much more once we have actually anonymous DAOs on chain. Then there's the other end of the spectrum, which would be full subjugation to state law. And that could be, for instance, that a corporated entity would spin off a DAO, or that the DAO itself would wrap itself into a legal entity. And this is a trend that we're seeing way much more, where this entity that is subjected to one jurisdiction and the laws of said jurisdiction will have control over the treasury of that entity. I added also over-compliance because as a result of FUD or fear, uncertainty, and doubt around these state legal risk questions, we've seen also several times projects that go even further than what they must do to comply and limit kind of their risk exposure. And then there is this in-between space where there are ways to try to bridge between the DAO world and the state law world. And it's, again, quite imperfect because it's very hard to create this translation method between these two systems that are not necessarily compatible. And this could be done through lobbying, and we've seen that with Koala, which is a legal think tank that published, I think 2 years ago or 3 years ago, the Koala model law on DAOs. And if this law is adopted by nation states, then it would give some recognition to DAOs and maybe even some limited liability to them, but it comes with some obligations, obviously, for DAOs as well. Regulators try to bridge between these two systems by creating form of corporations where DAO can easily plug into. But again, it comes with a lot of trade-offs. DAOs can use legal entities for parts of the project and not the entire project, otherwise it would be full subjugation. But for parts of the project, and because of various needs that they have, or individuals who are interacting with the DAO can also put an entity between themselves and the DAO as a buffer in case something happens. It's only this entity that would suffer from civil liability and not their own net worth. And it's possible, obviously, to move between these three realms with more or less difficulty depending on which side we are navigating. But there are obviously a lot of pros for using corporate structure as well as a lot of cons. And I've listed some of them here, and I think it's interesting to have a look at them. There are way more, and it's very jurisdiction specific and project specific. So this is just to give a broad idea. But the pros, I think the main one is the limited liability shield. So by having this entity, people hope that in case something happens, only this entity will be liable and not their own personal assets, for instance, which is obviously quite important protection. Then it helps, corporate structures help having a relationship with legacy systems. If you want to sign a contract where it needs a person or entity for it to do so, then you can do it through corporate structures. If you want to own physical things, it's easier, obviously, if you have the right to own, and this is given to corporate structures. If you want to sue, you have a standing in court if you're a legal person. You can use state legal systems as a tool to further the mission of your DAO. It is obviously extremely useful, even necessary, before true decentralization. So before we meet this threshold of decentralization that is actually undefined, it's not very clear when a DAO becomes sufficiently or is deemed sufficiently decentralized, but let's keep that aside. Before true decentralization, there is a concentration of liability and risk and power in the hands of a few. And it's extremely important then to use whatever tool the state legal system gives us to manage that risk. And it lowers FUD. So there is a lot of fear, uncertainty, and doubt because all of this space is new, it's untested, and by having a corporate structure, we have also a bit more peace of mind. Cons, it's hypothetical. These have not been tested. There is very few cases, almost none, from court systems that tries all of these different various strategies and structures. It comes with a lot of bureaucracy and overhead, obviously. It diminishes the autonomy of the DAO by subjecting it or parts of it to a jurisdiction, because that part or that entity will have to abide by the rules of said jurisdiction that also may evolve and change, and politics always evolve and change and are influenced by a lot of outside things that are out of our control. And in case there is a dissonance between what the DAO does and these norms to which it must abide, there is recourses through the courts or regulators. So it does diminish autonomy, which can lead to slowing down its potential. And if there are trends in the legal risk mitigation space that show later in time, because there are new court cases or whatever, that they were badly done or they did not serve its purpose, then that can harm also the entire space. I'm going to here briefly talk about two areas of FOD in legal risk mitigation and how actually it does impact a lot strategies of DAOs in whether or not they opt for a form of corporate structure. One of them is about general partnerships, and I don't know if this is a thought that is important to me because of my own echo chamber of lawyers in crypto, but I've put here this excerpt from a Forbes article that was published recently, and I'm going to read it with you. What is certain is that DAOs are a palpable legal danger to themselves and everybody associated with them, and folks who have something to lose should stay away from them entirely for now. Some bright lawyer is going to have to shoehorn DAOs into an existing legal structure, or else the result that seems likely in this case, everybody is liable as general partner, will play itself out. So we often hear, and lawyers also say that, and we see it published all over the place, that if a DAO does not have a corporate structure, it does not opt in for a specific corporate structure, then the default fallback would be general partnership. And what general partnerships means is that anyone who is considered a general partner, and who is considered a general partner is a big question mark, but anyone who is considered a general partner would be fully liable for the liabilities of the DAO. And obviously, if you have deep pockets, you're a VC, you're a whale, you have your own tokens, you participate in governance of a DAO, you may worry about being held sole accountable for whatever liability the DAO has in case things go sour. So it is a form of FOD because to my understanding and based on the research I've done, and if anyone has any other information, please come to me. I'm really curious about this. But no state court has yet said that DAOs or such entities or such organizations, are general partnerships. So this is basically solely based on FOD spread, maybe legitimately, maybe not, but it is extremely important, I think, to do the legal analysis of general partnership for every single DAO because it is not a default fallback in law. There are still conditions that need to be met for a general partnership to exist, and we have to see for whatever jurisdiction is most relevant to you, what are these conditions and whether or not they apply. Because it may be very well possible that it does not apply either because state laws cannot understand DAOs and cannot put it in one box. There are two cases that have been filed where the plaintiffs claim that the DAO is a general partnership, and these have been filed in the US, in California and New York very recently. I'm not gonna talk about it now because it's gonna be a whole talk by itself, but I'm gonna write a Twitter thread putting some information, resources for anyone who is interested in this case. My personal opinion, as I said, is that DAOs are not necessarily general partnerships, and we should do the analysis to know whether this FOD is legitimate or not in any specific case. Another type of FOD that is extremely present in the space is about economic sanctions. And this is for various historical reasons as well, but also because sanctions are becoming more and more visible. Now, Russia is also under sanctions, so the pool of people impacted just gets bigger and bigger over time. I put this tweet here because I find it very interesting. So basically, Bandex says, imagine being so scared, you correct your bully. So the OFAC, the Office of Foreign Asset Control of the United States, that usually puts this sanction list and creates all of, and points towards who is under sanctions, also publishes Ethereum addresses that are under sanctions and therefore should be blacklisted. And this project has implemented this list of blacklists, but has also realized that one of the addresses is invalid. But instead of just keeping it that way, it went a step further, corrected the address, and then corrected the list and implemented the blacklist with the correct address. And I find this example very interesting because it led to a lot of debates online and discussions about the legitimacy of doing what this project did. Because, and people argue often that it was basically unnecessary to go this step further, because this address, blacklisting an address, is basically and practically useless, because anyone can spin off another one and use other methods to just go around this sanction. And it leads to some form of absurd efforts deployed by projects to make sure that they are compliant, while it's not necessarily the most efficient or legitimate way to do so. The state of crypto law, it's all gray, and I postulate here that this is a feature and not a bug. We should use this all gray zone in order to actually use the full potential that we can see or discover of DAOs. And I don't know what DAOs can achieve, and I mentioned at the very beginning that it is a tool for civilization, and I gave some examples, but I actually have very, very narrow vision of what it can do, just because I think we're so early and so difficult to understand the full potential it has. But nonetheless, we should give it space to deploy that potential. And by doing so, we should have in mind that law does not equal state law, that the state law system cannot plug in directly into the DAO system, and there may be other ways to do just or legitimate actions without having to subjugate fully to one normative system. Voilà. Thank you for listening. This is my Twitter. Follow me. I don't know if I have time for questions.
Thank you. I have a question about the quotas law, the meme, versus something like, say, bankruptcy law, which is also a meme, but it's interpreted as law, right? Can you go over what, I think I heard you say that you're not a big fan of, or maybe I'm wrong, of quotas law. If you could go over that, and also if you could give us an opinion on Ricardian contracts.
Okay.
Ricardian contracts? You're not familiar, I'm sorry. Forgetting Ricardian contracts, assuming writing something on a napkin is a contract, right? Would you say that if you put into code such and such of a DAO is a DAO, blah, 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 would that be admitted as law?
Okay, I'm gonna first answer the code is law question, and then if I can remember exactly the second one, I'll get to that as well. So code is law. I'm not an advocate for it. I understand its purpose, and I find it beautiful as well in the context, first and foremost, of Bitcoin, because by having this very strict framework, you make it uncapturable or very difficult to capture. So because there's no governance, governance cannot be abused, for instance. So there are these pros, but there are also, I think, a lot of cons, because the way I understand DAOs is that it can provide this political space for people to get together, coordinate together, debate on what they believe should be implemented as rules of that DAO, or like what products, like what are the features of the products of that DAO. And by having a very governance minimal system, then you basically avoid all of these discussions, and you impose a system onto others. So it may be functional and work, but I don't think that it can stand the test of time. And I feel like it could be useful for some form of projects, but generally I would value more a political space of discussion, more democratic system. So that's for the first question. The second question about contracts. So contracts, what they mean by state law depends on each jurisdiction, and there are many different rules to meet for a contract to be valid. So for instance, if it's a contract about real estate sale, it has to be made by a notary in a written form and so on. If it's an employment contract in Switzerland, it can even be done orally. So I can just be like, do you want to work with me? I pay you such and such for so many hours. You say yes. We already have a contract, and there's already an employment relationship between us. So what is a contract depends very much on the subject matter of the contract and the people who are impacted by this contract that determine what state laws are applicable. Putting terms and conditions basically in a DAO code, if I understood what you meant, could be valid, but there is this big question of who will see that terms, who will understand them. Do you need to be able to read the code? Do you need to be able to audit it yourself? Do you need to be able to understand this concept in order to be bound by it or not? So I think that it's not necessarily contractor in the common sense that we understand it.
Hi. Question on dispute resolution. What do you think about platforms like Cleros or Aragon Court that have tried to sort of do this decentralized courts? Because I think, like you said, it's very useful to plug into the legacy system for things like contracting. But yeah, I'm just wondering why these decentralized courts haven't really taken off, or decentralized dispute resolution. Have you got any sort of thoughts on where you stand with that?
I'm not going to comment on these projects directly, but I think that having any form of dispute resolution tools that are opt-in can be useful if we look at them as tools and not necessarily as just. So the same way as state legal systems are not necessarily just, it does not represent justice, I think that no other dispute resolution mechanism can by itself, or maybe we should look at them as not representing justice, and then if we understand that, we can use them as tools. So what we've seen with the ones that are on-chain is that it really very much depends on the incentives, on what other incentives are also deployed spontaneously on top of it, on other projects. It is way much more complex, I think, than this just one court, basically, we go to that gives us an answer. But at least I think that there is value in finding good dispute resolution systems that are enforceable, because it just enables people to move on from a dispute onto something else. But if we, before even getting into the dispute, understand that if something goes wrong, then there is this recourse, and this recourse has these flaws and these features, then we can also use them very early on in order to preempt kind of these flaws being used against us. Okay. Thank you very much.